Is recording.
Hi guys, welcome back. Today we are studying community property. I want to apologize for not posting a video yesterday. I studied on my own, which was pretty much me watching videos, and I'm not really sure how to incorporate that into a video of me just sitting, reading outlines, and watching videos. But today we are back to the whiteboard and we are learning community property. So the first thing is you want to do on a community property essay is write out the following statements, and that is that California is a community property state. All property, let's do all P, acquired or earned during a marriage is considered community property. Property acquired before the marriage or by, we're going to do G, D, B, and that's gift, device, or bequest is presumed separate property. So that's what you're going to start your essays with, are these 3 sentences. So the next terms we're going to go over are quasi-community property and marital, economic community, MEC, common law marriage, and today's going to be a little bit longer of a video, so just keep watching. Non-married couples, putative, P-U-T-A-T-I-V, spouse doctrine, separate property, or as we used it, SP, tracing, and let me know if you make sure you can still see it. Can you still see it?
Yes.
Pre-marital agreement, marital excuse me, marital agreement, also known as a transmutation, and separation agreement. I'll put it over here. So we're going to go over these, and then we have a few more, but we'll do these to begin with. So first thing is community property. So as we said here, California is a community property state. What does that mean? Well, all property acquired or earned during the marriage is community property. So a term to know for that. We'll put this, mention this first, and then when applicable, quasi-community. So quasi-community property is property acquired by either spouse that would have been community property if the spouse had been domiciled in California at the time the property was acquired. AKA, it's property that was acquired that is considered community property. Well, there's two ways. Either one of the spouses has a subjective belief that the marriage is valid, and two, the property exists outside of California. Oops. So quasi-community property is treated as separate property for the duration of the marriage, but will be treated as community property at death or divorce. So it's SP until death or divorce, and then it is divided as community property. And what happens at death or divorce? Community property is divided 50-50. That's the general rule in California, is that all of the property acquired or earned during the marriage by either party is split at the dissolution of the marriage 50-50. So another term to know is marital economic community. And what this term defines is the span of time between this span in time when the marriage occurs, legally married, to the point in time that either death, divorce, or separation occurs. And what California says you need for death, obviously one of the spouses dies. Divorce, obviously there's a court-ordered divorce decree. Separation, California defines a separation as when a spouse expresses the intent to end the marriage and the conduct of the spouse is consistent with his or her intent. So basically, it's when they decide to separate. Now, also in California, this does not require physical separation. It doesn't require one of the parties to move out, so long as they're acting as a separated couple. This term, marital economic community, again, is to define this span of time. And so it's this span of time, which is when the community property is acquired or earned, and it's this span of time is when either divorce, death, or separation occurs that the court is going to attempt to separate it 50-50. common law marriage. It's important to note that California does not recognize a common law marriage. You may know a common law marriage in other states to be when a couple lives together for a certain statutory period, when they have a ceremony, basically some sort of ceremony, and they hold themselves out to the world as as husband and wife. That is what other states define as a common law marriage. Well, California doesn't recognize common law marriage. However, they will recognize a common law marriage that's recognized, that's validly contracted for in another state. So if it's been found to be a legal common law marriage in another state, then California will recognize it as a marriage, as a legal marriage. Next, non-married couples. So non-married couples, two people living together, do not have community property rights unless there was an express or implied contract agreement between the persons. And this is going to come up again. So basically, non-married couples do not acquire community property. Putative spouse doctrine, we're here. If a person has a subjective belief that marriage was valid, then the assets acquired during the marriage will be treated as quasi-marital property. So this circumstance may happen when one of the parties is already married. So let's say the husband is already married and the wife making his new marriage to wife 2 invalid, but wife 2 believed that the marriage was valid, then under the putative spouse doctrine, the property that they acquired during their marital economic community between that point that they got married and death, divorce, or separation will be treated as community property and divided 50-50. Well, specifically, it'll be treated as quasi-community property, which means it'll be separate property until death or divorce, then it's divided as community property. So, separate property, what does the court, so we know that the court defines all the property acquired or earned during the marriage as community property, but what does the court define as separate property? Well, California defines separate property as property as one, property acquired before the marriage, 2, any inheritance given to one party. And that's why up here we have GDB. D would be devise or bequest, and these terms right here define inheritance, forms of inheritance. So 2, inheritance given to one of the parties. Obviously, if the inheritance, if wife's parents give them $1 million together, then we know that'll be community property, not separate property. But in this inheritance is to one party, so the parents are giving to the wife individually or the husband individually. And 3, California defines separate property as a gift. So when a gift is given to one party that is personal in nature or not substantial in value, the court defines that as separate property. So specific things like clothing, some cases jewelry, things given within the marriage from one spouse to the other, or from another party to one spouse. Let's say the parents give the wife a vase. That vase is a gift to one of the parties, and so that would be seen as separate property. So another way that you can define the difference between separate property and community property is by tracing. You would trace the assets to determine if property is separate or marital, and any fruits of separate property will remain separate property. So the scenario is that husband has a bank account before the marriage, he acquired before the marriage. Let's say he's got $1 million in it. So we know right off the bat it was acquired before the marriage, so it's separate property. But let's say during the marriage he decides to buy a house with it, pays cash, buys the house. Question is this house separate property? And again, during the marriage, during the marital economic community, after the marriage, he purchases this house. Well, you may think, well, but it was during the marital economic community, maybe it's community property. But because we can trace the funds used to buy this house to the bank account that husband held before the marriage, then this is separate property. And so when we dissolve this marriage, the house would go to the husband. Does that make sense? Because any fruits of separate property, so this is the $1 million separate property, will remain separate property. So he bought the house with a bank account that he had before the marriage, and it's separate property. Similar circumstance, let's say if during the marriage he acquires an inheritance of $1 million and he decides to purchase a house. Well, we know the inheritance is separate property, and then the fruit of any of that separate property remains separate property. So if he purchased the house with that $1 million inheritance, then it's separate property. Okay? Can we move on? Do you have any more questions? Okay, so the next thing we're going to discuss is, so this is a word you want to define in your essay, and that's tracing, which is exactly what we just did. We traced this property to separate property. Pre-marital agreements. Pre-marital agreements, also you may know it as a prenup. Oops, that's not how you spell it. P-R-E-N-U-P. As a prenup are enforceable if and only if they've got to do a few things first. One, they have to be in writing. Two, they have to have 7 days waiting period to sign. They have to, 3, come with a full financial disclosure. Full financial disclosure, and they must have a separate attorney or they can sign a waiver waiving their right to a separate attorney. So if you are wife in this situation, you're the fiance in this situation, and your spouse, your soon-to-be spouse, comes to you with a prenup and they say sign it right now, well, and they don't give you the 7-day period, the 7-day waiting period to sign it, that prenup, doesn't matter what it says, is going to be invalid. The court's not going to uphold it because the court says no, it needs to be in writing. You have to have 7 days to think about it and sign it. It has to come with a full financial disclosure. What's that? It's a list of all your assets and debts. It's your financial situation that you're in. And then 4, you have to have access to a separate attorney, or you have to sign a waiver waiving your right to a separate attorney. And if you have all 4 of these things, then your prenup is valid. What's another thing to note about, because now we're getting into premarital agreements, marital agreements, and separation agreements. All 3 of these fall under contract law. So contract law terms like unconscionable, voluntariness, duress, fraud, failure to disclose a material fact, can all be used against premarital, against any of these agreements. So first of all, unconscionable involuntariness, and the court says for it to be that it would be unconscionable if you don't have access to a separate attorney. They also say it would be unconscionable if you don't have if it doesn't come with a full financial disclosure. And then voluntariness is if you don't get 7 days to sign it, and if you don't get a separate attorney, then the court says that it was unconscionable and it wasn't voluntary. What is this word when I write voluntary? I wrote a lot of this anyway. So a defense to enforceability of a contract are if the contract was made under duress, if the contract was made with fraud, or if the contract was made with a failure to disclose a material fact. Let's say wife doesn't want the prenup to be enforceable, and she'd like to claim that she was under duress, or she'd like to claim that there was a mistake. Also a mistake. She can use these contract defenses to defend any of these as unenforceable. So moving on, we're going to just talk about marital agreements really quickly. Marital agreements, this is also a really important phrase to use, because a big thing is in almost every community property essay, you're going to have a transmutation, but most people do not see the transmutation, so therefore they don't discuss marital agreements. But in almost every community property essay, you want to look out for a transmutation. And what's a transmutation? Well, it's an agreement made by the parties during the marriage. So during the marriage, and the court says that these are valid if they are in writing, signed, and so as long as they're in writing and signed, then the court will uphold it. So let's say husband and wife purchase a vehicle together, and wife says, well, if you leave me, who's going to get the car? And the husband could say, you'd get the car. Well, what do you want to say to him? Put it in writing, sign it. So if they put it in writing and sign it, then that marital agreement that she gets the car is going to be enforceable. And another thing about marital agreements is no consideration is required. So if husband says, when we get divorced, don't worry, you'll get the car, and she says, put it in writing, and they put it in writing and sign it, it doesn't need any consideration. That agreement's going to be valid as a transmutation. So on your essay, you can either put marital agreement or you can use this word transmutation, so long as you mention it at least in your essay. And another thing is that usually an essay tip is usually if there is a transmutation, if there was some sort of agreement by the husband and wife during the course of marriage, or husband and husband, or wife and wife, it's typically invalid because it probably wasn't in writing, it probably wasn't signed. Just in the fact pattern, if you come across that, that's probably what it was. So another thing, so we talked about premarital agreements. These are prenup, these are before the marriage, and these have to be in writing, 7 days to sign, full financial disclosure with a separate attorney. Then we have our marital agreements, a little bit less, you only need a writing signed. Then we have our separation agreements. So a separation agreement is an agreement between the husband and wife that pretty much discusses what's going to happen, who's going to get what. So at any point during your divorce, you can sit down as a couple and say, okay, I'll get the house in Cape Cod, and you can get the house in LA, and I'll give you $4 million, and I'll have sole custody of the kids. Okay? This would be a separation agreement, and the courts typically always enforce a separation agreement. So long as, on contract law, it wasn't made under duress, there wasn't fraud involved, the courts, California, are going to uphold the separation agreement. So you at any point in a divorce can decide how you'd like to decide, I don't want the courts to do it, I'll do it. We'll decide our own destiny, and and California is going to enforce that separation agreement. All right, can you hit pause?